This video is a response to Mr. Ernest Dronenburg, who is the county clerk of San Diego County in California. Last Friday, Mr. Dronenburg filed an emergency petition with the California Supreme Court asking them to immediately stop gay marriages statewide, except perhaps in the two counties where the parties to the successful defeat of Proposition 8 reside. Mr. Dronenburg went on to say that he needed clarification, that he didn't understand the implications of the recent Supreme Court ruling on Proposition 8. Well, Mr. Dronenburg, there's a very good reason why you can't understand the Supreme Court's recent ruling on California Proposition 8, and that is because the Supreme Court didn't rule on it at all. What they said was that groups like the one founded by your by your lawyer, had no standing, that they were not entitled to appeal the decision that was handed down in 2010, so 3 years ago now, by Judge Vaughn Walker at the 9th District Court in San Francisco. So, the net effect when a party attempts to appeal to a higher court and they are told that they may not appeal because they don't have standing is that their appeal becomes null, as if it had not happened. And since there have been no other appeals and no party who is in a position to appeal wishes to appeal, the net effect is that the ruling handed down by Judge Vaughn Walker in San Francisco in 2010 is now, in effect, the result of all of the court action over Proposition 8. And in that finding, Judge Walker found, number one, that the arguments put forth by your lawyer failed to make any sense, that they were not rational, that they used tautologies. You can look that one up. And they also said that Proposition 8 fails the due process requirement of the Fourth Amendment to the U.S. Constitution, as well as the equal justice under the law requirement or the equal protection of the law requirement in the 14th Amendment to the U.S. Constitution. Now, you made the claim that perhaps only the two couples, consisting of 4 people, 2 men and 2 women, who raised the objections to Proposition 8, only those people would be affected by the recent court actions. Well, your suspicion might be correct if a certain 2 things were true. And that would be if those 2 couples are the only people in California who have the right to due process under the law, and if those 2 couples are the only people in California who have the right to equal protection under the law. And since that is not the case, it becomes very clear to anyone who has ever read Judge Vaughn Walker's decision. I'm not a county clerk, but I did read it. It's clear to anyone who's read it that it applies to every person. So what I need to tell you, Mr. Dronenburg, I don't think you've realized this even yet, is that this court action restored to you a right that had been taken away from you to marry someone of the same gender if that happened to be what you wanted to do. Now, it may be that you don't have any intention to marry someone of the same gender, but most people don't. We'll grant you that. But you see, having a right taken away and doing nothing about it might not be a good idea because people change. And something you think is not important now might be important later when your mind has changed or your circumstances have changed. So don't let people legislate the rights of other people. That was the base problem with Proposition 8. that a majority tried to restrict the rights of a minority without having a legitimate basis or an actual need to do so. I hope this clears things up for you, Mr. Dronenburg, and I hope you are successful in your debate about whether you should do your job or follow your religious beliefs, whichever you choose best to you.